Welcome back to this high-level conference for a people-centered eJustice. We are now entering the final sessions. The debate that follows brings one of the biggest concerns when it comes to technology in justice, the use of artificial intelligence. Being one of the most exciting and promising technologies, it poses real challenges and fears as we are moving through uncharted territory. As we just saw in the video, there are concerns about the automation of judicial decisions, and that brings us back to the crucial role of the kind of debates we settled for these 2 days. New technologies, either tested or emerging, like artificial intelligence, augmented reality, blockchain, or the Internet of Things, they increase the pace of the digital transformation. But we all know there are real, huge dangers just around the corner. It's absolutely imperative that these technologies are used for good, pursuing the principles of equity, transparency, and the protection of human rights. Please welcome Professor Arlindo Oliveira. Is president of INESC, the Institute for Computers and Systems in Portugal. That will be the moderator of the next session, focused on the responsible application of artificial intelligence, AI for good. Please, Arlindo, the floor is yours.
Good afternoon. Thank you for the invitation. It's a pleasure to be here. Also like to introduce and welcome and thank the panel participants, Virginia Dignum, who is Wallenberg Chair on Responsible Artificial Intelligence at Umeå University. We will not able to count with Luciano Floridi due to personal difficulties, but we'll have Michael O'Flaherty, Director of the European Union Agency for Fundamental Rights, and Gregor Strojin, Chair of the Council of Europe Ad Hoc Committee on Artificial Intelligence. Thank you very much for being here to discuss this very interesting topic. As we heard, there are a number of technologies that are changing society, certainly the digital revolution, blockchain, mobility, all of that. But artificial intelligence plays a particular role in the sense that it impacts all areas of society. In the same way that we can view just artificial intelligence as successively more sophisticated systems that are approaching human-level intelligence in some specific aspects, and that has many, many applications in many fields. And of course, as we rely on ever more sophisticated systems, a number of things are cause of concern. Are we protecting the fundamental human rights? Are we putting too much hope and too much confidence on automated decisions or in semi-automated decisions? What are the consequences on privacy? What are the consequences on security? The use of artificial intelligence in a variety of domains, of course, has impacts in all those fields. We can also imagine that by combining artificial intelligence and natural intelligence, we may reach better decisions and more efficient processes than by using just one of them, but there are also risks in this. Many of the systems now actually learn by experience. They use machine learning to derive new algorithms and new methods, and every time you learn from experience, you have to be concerned what experience are you learning from. And there are challenges in making sure that these systems are learning the right things, they are learning from the right databases, that the databases have the right data. And of course, there is a variety of applications in the justice area that go from test processing, summarization, looking at precedents. There are many, many applications that are very interesting and very relevant for us to discuss here. So I will probably start with Virginia. This area of, in particular, of the ethics of AI is an area where you have been focusing your investigation. In particular, you have defended a number of times the need for a responsible use of artificial intelligence. Do you think that the models and the legal setup that we have now and the documents that have been produced by the European Commission and the European Parliament are in the right directions? Are they effective in protecting citizens' rights and making sure that AI will be used for good?
Thank you very much. Boa tarde, good afternoon for all. Yes, I have been working for many years, not only on the responsible use of AI, but also the responsible development of AI. And I have been advising many different organizations from the European Union, the UNESCO, UNICEF, and many others exactly on these issues. How can we ensure that AI is developed and used in a way that respects and supports our fundamental rights, human rights, and also the fundamental universal values that societies hold. One issue which is always underlying this is the need to understand what exactly is AI, not so much a technical definition of what's AI, but really understanding that these systems are, in a sense, they are very different from intelligence as we would talk about human intelligence. They are maybe less intelligent than people in the sense that most of the systems that we are using nowadays, which are extremely good to make inferences and to identify patterns in a huge amount of data, are usually very bad to understand the meaning of those patterns. So this disconnection between meaning and patterns or the meaning and the decisions is something which we really need to take into account. But at the same time, AI is more than intelligence, or is more than technical systems that we are dealing with. And we really need to address the whole social technical infrastructure or the ecosystem in which the systems are developed. So it's not only about regulating or dealing with the technology itself, it's about also regulating and understanding and supporting those that develop, research, monitor, use, so the whole chain of actors in the chain of development and use of AI. A lot of what we see in terms of what these regulations are dealing with are very much based on identifying fundamental values, fundamental principles, and also identifying which type of applications are of more or less risk. What I think is the step that we really need to move on forward is the step of interpreting and operationalizing this type of principles and recommendations for AI. In a sense, it's much simpler to say that we want these systems to be fair, to ensure inclusion and diversity, to be dealing and adhering to principles of human rights and human agency. But once it gets to really implement and verifying that systems are indeed doing as we hope, it's a quite complex and a quite difficult issue to deal with, and one which requires a multidisciplinary approach. So we really need to look at the development of these systems, not only from the perspective of what we can do technologically, but we need to broaden it into a multidisciplinary discussion and participation in which we try to combine what we can do technologically with what we should be doing, or what is the best to do from the perspective of human rights and fundamental human principles.
Gregor, I'm sure you have been following the recent developments in legislation and regulations that were drafted by the European Commission, in particular the Artificial Intelligence Act that was released just a few days ago. Do you think that these regulations are going in the right direction? Are they appropriate? Are they the appropriate legal framework? Or you think there is a lot more to be done? And of course, I know that you have been involved with the ad hoc committee on artificial intelligence. Do you have any additional ideas, things that should be done more strongly maybe, or in a different way than what has been done by the European Commission and the European Parliament?
I think this proposal from the European Commission, which was introduced last week, is definitely a necessary first step. I think it also shows a lot of courage and determination from the European Union to put forward this idea that AI, responsible AI, a human-centered approach to AI, it is definitely a good first step, but it's a step which really needs to have a much bigger continuation, and also a lot of, like I often say, the devil is in the details. I think that there is a need for working out quite some of the details. For instance, issues which I think that we really need to take into consideration is how to present and propose this regulation not so much as a restriction on what can be done in innovation, but exactly to propose it and to show and to frame it as an opportunity, a stepping stone for innovation. And I'm fully convinced that this is what is meant by the regulations, is what is in the minds of the European officials that developed this proposal. But I think it needs to be much more strong in terms of ensuring that it's not just about penalizing or beating those that don't adhere to it, but really showing that this is the way forward, that this is a real stepping stone to move into an AI that we can trust, an AI that is human-centered, and an AI that it's really supporting the development and innovation in Europe along those principles that we as Europeans find the most important. I'm convinced that this regulation is also bringing together a whole new effort, a new area for development in certification, in auditing, in monitoring of this type of systems, because it's not something which can be done one-off, but it really needs to be integrated in the very body and the systems and the very technical code and programming of the system. So we really, I think that it's a step which will bring forward a new and improved approach to AI, which combines the capabilities and the enormous opportunities that we have by using AI to analyze and to manage data, but combining that with a more human-centered and trustworthy AI that is able to explain and is able to be monitored, to be transparent, and to provide the needed steps for accountability and for responsibility.
Thank you, Virginia. So, Michael O'Flaherty, good to be that you managed to solve your technical problems. Thank you for being here. So, do you think that as we develop and go forward in eJustice, and especially with the possibility of using artificial intelligence to partially automate some of the procedures, are we putting fundamental rights in danger, or are we at least in danger of losing control of the way we make sure these fundamental rights are secured and defended? Do you think this is a danger, or those are things that don't worry you?
Well, if you put it like that, thank you very much for the invitation. It's a pleasure to be here. I'd like to associate myself with what I heard from Professor Dignum just now. I came in late because I had a technical problem. My apologies. Before I'd even answer a question about whether fundamental rights are at risk, I would just recall that fundamental rights are non-negotiable. They're captured as legal binding norms in the Charter of Fundamental Rights and elsewhere. And indeed, we have to keep that front and center stage at all times, including, for example, as we read the impressive Berlin Declaration. Article 1 of the Berlin Declaration about issues of fundamental rights and values must be understood as supporting this concept of the non-negotiability of the legally binding rights. Now, that said, from a fundamental rights point of view, eJustice can deliver great goods. Let that be the frame. Let that be the primary basis for our discussion. eJustice can deliver speed. And speed is at the essence of justice in so many cases. It can support fairness. It can support access. It can greatly support data security. And there are many other values to the application of eJustice, and we must continue to acknowledge those. But that said, of course, it's risky. Of course it is. And that's why the draft artificial intelligence legislation identifies it in the category of high risk. That's not saying it's bad. It's just saying that given its importance, we have to proceed with care. We heard earlier this afternoon from the then moderator about the need to protect privacy. And I agree with him, and privacy is center stage, but of course it's just one of many human rights that are at risk, that need to be carefully protected in this context. I think of what we call in English equality of arms, the fairness of procedures with regard to both sides of an argument within the courtroom, the related issues of access to justice. I thought what Professor Hadfield said to us at the beginning of this afternoon's session was fascinating, about how not every law firm has the same resources to go online, and that raises issues of equality of arms that need to be taken account of. Very important for us at the Fundamental Rights Agency are issues of non-discrimination, about making sure that everybody equally has access to just justice. We know that algorithms can discriminate. We know it from our own research and work at the Fundamental Rights Agency. We've seen how algorithms with inappropriately loaded learning and data can discriminate on the basis of gender, race, accent, dialogue. We're using translation tools at the moment in the courts in many places, and we know that there are problems here in terms of misunderstanding accent, and there's a correlation there with socioeconomic status. So these are fixable, but we have to be acutely alert to them. And then finally, in terms of the range of rights, there is the very specific to the EU right captured in the Charter of Fundamental Rights, the right to fair administration. So every application of artificial intelligence and the digitalization of justice must recognize the need to honor that right. And the last thing I'd say, by way of response to this first question, is that we have to be especially vigilant, because we know from our own research at the Fundamental Rights Agency that a primary driver for digitalization in our lives, this is not justice specific, this is across all the sectors, a primary driver is efficiency, not quality. If the primary motivation for investing in the tools and the technology is to get more of it done faster, and that's in itself good, obviously, but nevertheless, it has to be watched with that extra element of vigilance to make sure that in our speed, we don't make mistakes, and in this case, trigger issues of human and fundamental rights.
Yes, that point that the digital transformation is more on the efficiency side than on the quality side is an interesting point. Is of course not only for justice. Of course, in Portugal and probably in other countries, we do worry a lot about also efficiency in justice, in the sense that sometimes justice is slow and people feel it's not, this slowness does not serve well justice. On the other hand, these new technologies and artificial intelligence in particular, they can also maybe play a role in making justice more inclusive, in the sense that people may have an easier access to and understand better decisions or even complicated legislation or their own rights or so on. Do you think that artificial intelligence can play also a role in making justice more inclusive?
Yes, certainly it can, but in order for it to make justice more inclusive, we have to ensure access to it. We have issues of the geographical spread of internet access, of poor quality in rural districts. We have enormous issues of building up of knowledge, awareness, and understanding of literacy in the digitalization of life for litigants, but also for their lawyers in many places. There are issues of access by otherwise vulnerable and marginalized groups, and of course the access of people with disabilities. every single one of these can be dealt with. But before we can say that eJustice is bringing a more level playing field, we have to be aware of the conditions that need to be in place so that it can deliver on that level playing field.
Thank you. So, Gregor Strojin, thank you for being with us as chair of the Council of Europe Ad Hoc Committee on Artificial Intelligence, CAHAI, I think it's. You are the right person to tell us what does CAHAI defends as the right legal framework for artificial intelligence in general, but also in the justice area.
Thank you, Arlindo. CAHAI has been tasked 2 years ago as an intergovernmental body at the Council of Europe. CAHAI means Ad Hoc Committee on Artificial Intelligence. We have a 2-year mandate to conduct a feasibility study on design, development, and application of AI on standards of human rights, rule of law, and democracy as put forward by the Council of Europe. And we are tasked with elaborating elements for a suitable legal framework. And we have conducted the feasibility study last year, and we have established that we need both a combination of a binding and a non-binding legal framework comprising of a horizontal instrument and sectoral vertical instruments. We have established also that we do not live in a legal vacuum at this moment. We already have instruments that are addressing various challenges that are posed by AI and its implications. However, their use is fragmented, it's cumbersome, sometimes it's lacking. So I would say that a lot of work has already been done, and I appreciate the input put forward by the European Commission with their proposal last week. I would note that what we are doing is going a bit further from impact on human rights or fundamental rights, but we're also looking at the societal dimension of democracy and rule of law. And we're looking at the impact on how these challenges can be addressed both as a risk and an opportunity. So I think this is something that will be addressed by various sectoral bodies of the Council of Europe and wider. I would also stress that it is important that we take note of different capabilities and also mandate of different international organizations. As in the past, also now, we should put appropriate tasks and appropriate challenges to individual organizations. And as GDPR depends on the previous success or impact of Convention 108 or 108 plus, or cooperation and legal matters of the European Union depends on the Budapest Convention, I would say that it is important that we also align the work of the European Commission, European Union, and Council of Europe when it comes to artificial intelligence. Also in terms of trying to become a global standard setter, we need a treaty that other countries, non-EU members, also non-Council of Europe members can align to or adhere to. I would just like to make this distinction also that this morning I spoke at a conference organized by Azerbaijan. Of course, this is only possible in the times of pandemic, that in the morning I'm in Azerbaijan, in the afternoon I'm in Portugal, and in the meantime I was in Strasbourg, where we held the CAHAI Bureau meeting preparing for the next plenary. And I would say that all eyes are on Europe in the wider context, trying to find solutions to the challenges and problems. And I would say that it's important to be fast, but not too fast. We need to find the right solution. As Michael was saying, that we are putting a lot of effort when using applications on efficiency and not on quality. I think it's the job of Europe and all its organizations that are being composed of member states, which are present also here, that we are looking for quality that will enable us to, first of all, solve the problems that are being caused right now, also by dumping of various applications which are not consistent with the way of life, if I am allowed to say this, but more appropriately with the human rights standards, rule of law standards, and potential democracy endangerment. And secondly, to move in the direction of development of applications where we know what we want, where especially public sector knows what it wants, and that it knows how to go about developing it. So this would be my introduction before I move to additional questions from you.
Yes, let me just follow up on that. You made a reference to the fact that other countries are looking for Europe, and Europe has certainly played an important role with new legislation in what concerns rights and privacy and so on. Should we be worried that, I mean, maybe not all countries are looking forward to Europe. Should we be worried that, for instance, China or the United States may have or may use weaker legislation and get a head start on more advanced AI techniques? After all, most of the largest companies in the world that use and develop AI are not European companies. They are either American or Chinese. Should we be worried about this, or you think that Europe will actually play a leading role and other blocs and other countries will actually follow our lead?
I think we should primarily be worried about things that we can control and that we need to control. And this is control how European countries are using various other technologies. What we're seeing right now in a number of countries that we have AI applications used without the legal basis. Sometimes things that are mentioned in the red lines of the European Commission's proposal are being used for security issues. And I think this is unacceptable. And sometimes they are used because they are being offered by external countries. Sometimes they are developed internally. What's important is to solve the problems of our own making first, and then worry about external players. We cannot control both.
Thank you. So Virginia, I come back to you. Of course, one of the issues that is being raised by modern AI techniques, and in particular machine learning, is the issue of transparency. These systems are sometimes described as black boxes, and they may be more black or less black, but certainly they are not fully transparent in all cases. And in the justice area, I think it's particularly important that these systems are transparent. Do you think we can, do you think it's possible to develop systems that are both effective and efficient, of course, but also transparent and understandable so that we can trust in them, for instance, for a medical diagnosis, but more in particular here in the justice area for a particular, I don't know, suggestion of a decision or an explanation of a decision? Do you think we can trust the transparency of these systems, or at least that we can in the future develop systems that are transparent and understandable?
The short answer, yes. And now the more complex answer. I think that actually the legislation and the regulations that we're putting in Europe will be exactly the stepping stone that we need to build these systems. I'm not worried about this race with the United States and China or whatever. It's about building systems that are both efficient and transparent. Efficient, and I wouldn't not even use say transparent, but efficient and trustworthy. And by setting the standards for the regulation that we only accept this type of systems, this will boost innovation, will boost research, because we really have to step further than the current, let's say, easy and lazy way of putting more data and more computational power and try again and again the same algorithms that we know of. But we really need to move ahead of that and start really looking at new types of algorithms, new types of technology, probably hybrid types of technology, which combine the power of the processing data with the capabilities of representing and understanding meaning, which have been the focus of the, let's say, the old-fashioned AI things. But by combining both of them, we will develop these systems which we can trust and which are efficient, as efficient, or at least as efficient as the ones we have now. Talking about the issue of transparency, people are also not transparent. We are black box to each other, and especially in the justice field, it's not always clear as well that we know exactly what were the reasoning, the motivation of judges, of juries, of the whole judicial system. So we really need to look at it again from a multidisciplinary perspective. Yes, we have to build systems which are explainable. Yes, we have to ensure that we provide as much transparency as possible from the algorithms and the techniques that we are using. But at the same time, we have to develop the institutional and the social mechanisms which deal with accountability, which deal with the responsibility for the decisions of the systems. It cannot be never that someone gets a decision, either in healthcare or in the judicial system, which is, sorry, the system, the computer, the algorithm said that you have this or that situation. So the computer says so or the computer says no is definitely not an acceptable decision, and it's a decision which needs to be scaffolded by a whole stronger development of the agencies to deal with accountability and deal with the responsibility alongside with the transparency. Actually, we often refer to these three as art: accountability, responsibility, and transparency. And like in art, we really need to find a balance between all the different ones, which is not just a technical engineering type of balance. It's more indeed an art.
Thank you. So actually, I would like to share with you that hope that we'll be able to write fully transparent and understandable systems. I'm not so sure it will be, well, certainly not trivial, but let's hope it's possible. Anyway,
it's maybe not our generation, but I have to hope for the next generations of AI researchers.
So as you are well aware, the artificial intelligence technology, and in particular machine learning and natural language processing technology, is evolving very rapidly, and we are now able to build very, very complex models that have surprising behaviors at times. And it's not completely unthinkable that we can, with existing technology or near future technology, program a system that can make judicial decisions by itself, either in simpler cases or in some cases. I asked Michael, do you see this as a, well, first as a risk or a possibility, but more to the point, do you see this as a menace to fundamental human rights, that sometime in the future we may be thinking about being judged by machines, at least in some specific cases and conditions? Do you see this as a potential violation of human rights, or at least a risk?
Well, it's not keeping, thank you. It's not keeping me awake. I see the development of AI and our engagement with it and its application in the justice context fundamentally as positive. Let's never forget that even in its most advanced futures, AI is a human creation driven by human input, driven by humans. It's not science fiction. And if we keep that at the center of our minds, we will manage the phenomenon. Maybe in the future, in low-level judicial context, there will be proposed decision-making coming from the application of algorithms, but that will be and must be subject to human review. So we watch this very carefully, but as I say, I think it's important to recognize that it's human-made, human-driven, and humans are subject to regulation by law, including human rights law. But let me come back to those really interesting questions you were asking the colleagues just a moment ago. Firstly, are we worried that somebody else, somewhere else, is going to jump ahead of us with the technology? Well, I'm not worried at all. Because the best technology is going to be the highest quality technology, the one which has the ethical and normative elements hardwired into it. And that's competitive technology, even in the marketplace. People don't do forum shopping for the quickest, easiest outcome. They want the most predictable and enduring outcome. And so, to the contrary, I don't think our justice, international global justice, is going to go flying off to some place where the standards are problematic. To the contrary, I think it'll be a draw. We see this with GDPR. GDPR is a tough law, but it's been copied everywhere else. And I'm not aware of any great harm done to Europe because of its rollout. Secondly, on transparency, forgive me for jumping in on this as well. But look, when we're talking about the application of artificial intelligence in the context of justice, transparency is not an option. If we can't have transparency, don't use the technology. How else can we ensure justice? And we can do this. Yes, we may be using proprietary materials, but we're using them in the public service. And so through the normal public procurement, we must insist on a full transparency so that nobody is surprised. And lastly, in terms of monitoring the fundamental rights impact of the application of artificial intelligence in the justice and other sectors, let's never forget that that compliance assessment is not a once-off. It's not an ex-ante test. It requires to be applied on a constantly. And this raises an issue probably a bit beyond our scope today of putting in place sturdy regulatory systems, including at the national level. This is unavoidable if we're to manage the threats and the risks on an ongoing basis. Oh, and my last point, forgive me, too many last points. We deal a lot with industry in the Fundamental Rights Agency. Industry in terms of the people who design the systems and the people who use the systems in public and private sector. And I don't see any great resistance to human rights respect. On the contrary, sometimes I see some uncertainty about how to do it. But in our experience at the agency, governments, institutions, the corporate sector, they want to get it right. They need help. And that's where the focus of attention should be, how to support them.
So, Gregor, I direct this question mostly to you, but feel free to for anyone to answer, which is, what use cases, what particular applications do you view as more coming in the short term as real field applications of artificial intelligence in justice? Of these, which ones do you think they have the better trade-off between benefits and risks?
Yes, thank you. This is a bit narrower than what we're doing at CAHAI, because this was partially already addressed by another Council of Europe body, CEPEJ, which produced the ethical guidelines for use of artificial intelligence in justice, I think 3 years ago. But while I'm at CAHAI, I'm also at the Supreme Court of Slovenia, and we're doing a couple of projects using AI, test projects right now, which can show the benefits and low risks by increasing the capacity of the justice system. For example, one that is very beneficial to the judicial system and can release the resources for other applications would be anonymization of decisions, which allows further dissemination of case law without jeopardizing the personal data. This is something that is very cumbersome and resource wasteful if it's done by hand. Another thing that can be done is analysis of the existing case law as a tool for judges to look at the elements where they might have bias themselves, but they do not understand it or do not see it when they're judging the cases. What we did, what some researchers in Slovenia did a while ago, is look at certain types of application and realizing that judges put more emphasis on certain elements of a crime or a liability case than on others. And if they put adequate emphasis on all of the elements, their end result would be less biased. So in all these both these applications, we don't see a high risk for the final user, but we see use that can release the resources of the judiciary so that they can be used for other purposes. For example, for decision making, which would be quicker, and then we can go into next stages of how we use the technology. We can use it for triage of cases. We can use it for finding the relevant elements of the lawsuit when we have mass lawsuits. It all depends on basically on the literacy and understanding of the let's say IT department of the judicial system on how to use the technology. So it shouldn't be mass procured. It should be grown by basically domestically. And here we come also to the similar reply that you received before by my other co-locutors. We shouldn't be that much concerned about what is happening elsewhere. We should be concerned about knowing what we want and how we achieve it. And through that, we can fulfill the potentials that are at hand.
Thank you. That's a few interesting suggestions indeed of empowering the judges to make better judgments and they have more access even to statistics and other data that may help the justice system. We are now approaching the end of the session. I will just ask if any one of you wants to make a very quick statement, let's say a 30-second statement or comment to what has been just referred in the last round, and then I'll have to close the session. Go ahead, Michael.
Thank you very much. I would just speak on one point: training, training, training. We absolutely need to invest in training among lawyers and judges for this next generation and the application of AI in the justice system. There's an enormous literacy gap right now that has to be addressed very quickly. That's it. Thank you.
Anyone?
I would fully support Michael, and also in this training, really making the point that Michael also said, that these systems are not magic. They are systems built by people with very well set purposes, and that we really need to have the discussion about what is the purpose of the system and how is the system serving and being used by the judges, by the judicial system in a way that benefits their own and empowers themselves in their own positions, rather than having this feeling that it will be some kind of magic thing which comes from outside and takes away their jobs or takes away our own right to justice and to agency.
Thank you. Gregor, any final comment?
Yes, thank you. I agree completely. We shouldn't consider it science fiction. We should focus on literacy, but we shouldn't look only at individual impact, not only at fundamental rights for an individual, but also look at the impact that is caused by the scalability of the technology. And this is where we come also to the issues that are quite pressing, which are democracy and rule of law in general.
Thank you. So I think we had, thank you very much for your comments and your interventions. I will not try to summarize everything, but we heard here about the importance of transparency and auditability, the importance of inclusion, digital inclusion, but also justice inclusion. These ideas of empowering the justice, the judges and the people in the judicial system with technology that does not replace humans but makes them more powerful and more fair and more knowledgeable. And of course also the drive that is always present for efficiency, and certainly we all agree that artificial intelligence and digital transformation will play an important role in increasing the efficiency of the system. And interestingly enough, we did not hear a lot about threats, about menaces. So I think we are all relatively positive after all on the application of AI in the justice domain. Of course, with a careful analysis of all the issues that will always be raised by such a powerful technology. Thank you very much. This ends our session. Thank you for your presence.
Thank you.
Thank you.
Thank you very much also, Professor Arlindo Oliveira, for this truly interesting conversation. Technology is inevitable. Being aware of all the dangers is an important step to pave the way to use the better tools for good. We must not allow any approach, any sense of some dystopic world like 1984, the George Orwell's novel that has been recently republished. For those who have forgotten parts of the story, remember the Ministry of Truth and something that echoes strongly in me, the nova lingua, the new language that was adopted to prevent in the story any kind of rebellion. For me, I'm a journalist, it's always of capital importance, the use of language. I dare to say, after these 2 days that made me deep dive in some issues, obviously complex and challenging, that is a real need to be clear as much as we can. Transparency and justice begins with the language we use, for sure. Words can trigger anything, but only words can settle everything.